Hello, my friends. Recently, the Consumer Protection Bill has been passed in the Rajya Sabha also, and it was already passed in the Lok Sabha. And therefore, the number of queries and questions have been put to me by doctors and others also that whether under the new Act of Consumer Protection Act, label it as new Act, whether the doctors have been excluded from the purview of the Consumer Protection Act. So this is an important significant point for discussion today, and therefore I decided to have a freelance open-hearted talk with you by way of this video. For that purpose now we will have to find out and go to the root of it. As you are aware that the Consumer Protection Act 1986 was framed and legislated as per the directions of World Health Organization, and the consumer was supposed to be protected by way of this act from unfair trade practices and from deficiency of services. Now this was necessary because the WHO directed Government of India to frame and legislate this act, otherwise the aid would be stopped to Government of India, and therefore it necessitated the framing of this act. Thereafter you will find that in this act, that is of 1986, we can call it as old act. In the old act also the healthcare was not included in the list of services. And in the year 1995, when Honorable Supreme Court delivered a judgment in case of VP Shanta versus Indian Medical Association and declared in no uncertain terms that doctors and medical practitioners and healthcare professionals would be liable for deficiency in services, as the patient has become a consumer of them. Therefore, since thereafter, now, as per the old act, the cases have been filed and lodged against the medical practitioners. Now, by way of this present legislation of latest law of Consumer Protection Act, we have to see whether healthcare professionals have been given immunity or are likely to be also dragged into the court of law. For that purpose, now you will find that there are two lists in the new act. One is the inclusion list and second is the exclusion list. And in the services, details of which have been mentioned in the inclusion list, the word healthcare professional was previously included in the bill at the time of its passing in the Lok Sabha. However, due to opposition to it by number of members, the healthcare has been dropped from the inclusion list. Now, one thing is very certain that because healthcare is dropped from the inclusion list, whether the doctors have been exempted totally and whether the medical practitioners have been given a blanket protection from Consumer Protection Act. But then, by way of interpretation, one can easily say that that is not the case. If they would have excluded them, specifically excluded healthcare professionals in the exclusion list, then it would have been proper to say that the medical professionals and the healthcare professionals have been excluded from the purview and ambit of the new Consumer Protection Act. But since it has not been done or it has not been specifically excluded, we feel on the strength of the available data and material that is available as on today, that medical practitioners and healthcare professionals would still be liable in case of deficiency of services. Thereafter, you will find that the Supreme Court has laid down the case law, and that case law has not been overruled till today. VP Shanta versus Indian Medical Association, then there is Jacob Matthews case also, then there is Agrasen hospital case, in which you will find that the Supreme Court has held medical practitioners liable for deficiency of services. So long as by way of judicial scrutiny and judicial pronouncements, the medical practitioners and healthcare professionals have been held to be liable for deficiency of services, even under the new act, they will be liable. And in the list of services, they have not been specifically excluded, only their service has been not included in the inclusion list. That is not enough for them to come out of the purview and ambit of the new Consumer Protection Act. Therefore, I feel that in the circumstances of the case, in the present position, the position of law as it stands today is that the medical practitioners should again be cautious, careful, and they should not be misled into believing that they have been given blanket permission and blanket immunity from the operations of the Consumer Protection Act, that is, New Consumer Protection Act. Only the exception in this case in the new act is that if the services rendered are free of cost, then in that case the medical practitioners, they would be exonerated, or they will not be able to be sued in the court of law. Otherwise, if anything by way of say donation or anything by way of say fees is accepted, then they would be definitely liable under the new Consumer Protection Act also. One thing is certain, that this has given a good ground of defense for the doctors. This can be raised as a good ground in consumer cases. But then, going by the judicial interpretation, going by the case law, going by the general judicial pronouncements, and the law that is existing today, medical practitioners are still would be liable in case of deficiency in service. So, it is better for them to remain protected and to to see that there is no wrong committed on their part, and maximum precaution is taken in tackling and handling the patients in all aspects of the matter. Therefore, my this last suggestion would be that the doctors and the medical practitioners and the healthcare professionals need not be upset by the Consumer Protection Act. It is the law of the land. You have to live with the law of the land. You have to change yourself. You have to adapt yourself to the changing situation. And if you are sincere, if you are particular, if you are ethical, if you are clear in your aspects, in your treatment, in your operation procedure, in everything, and if in documentation also, and in assessing the patient, then there is no cause for worry, as the ethical and good doctors, they will ever be protected by the society and by the people and by the legal practitioners also. Thank you.